All right, former Trump White House Chief of Staff Mark Meadows was not present today for a deposition with the January 6th committee.
Now, the committee had threatened to hold Meadows in contempt if he did not show up. So let's bring in distinguished university professor at Touro College, Thane Rosenbaum. Thane, your take on this?
Well, I'm not surprised he didn't show up. His position has been, look, I served in a senior position in the Trump administration. There's a longstanding principles of executive privilege that apply to the senior staff. And you can't compel me to testify to something that I said to the president in the capacity of his advisor, right? He's saying the purpose of the privilege is so that I could have open and frank conversations with the president and give him my advice. And I inherit whatever privilege he has because I was serving in that capacity. The problem is that Joe Biden has waived the privilege. So the legal question is the privilege, the executive privilege, unique to the president so that it travels with him or her when he leaves the White House or she? Or does he forfeit the privilege once he or she leaves the office? And now the new president either can waive the privilege or restore the privilege for Donald Trump. And in this case, President Biden said, we're waiving the privilege. We want this documents. We want this information from the National Archives to help the Oversight Committee in Congress on January 6th.
Yeah, and this is a former president, and the question might be, even if there are important conversations, if they're in the past, do they apply now? So Meadows' attorney says the issue of executive privilege is not one for his client to decide. Quote, legal disputes are appropriately resolved by courts. It would be irresponsible for Mr. Meadows to prematurely resolve that dispute by voluntarily waiving privileges that are, well, it went beyond me. But anyway, go ahead.
Yeah, Bob, no, he's right on that regard. This raises an interesting constitutional question that hasn't been resolved. Right.
So does it go to the Supreme Court thing? Is that where this is going?
Good. Well, let me just say, in this case, it's very likely because what the appellate court did yesterday was simply block the order so that the National Archives do not have to release the documents now. Remember, the documents are not in Mar-a-Lago, right? They're in the National Archives. So President Trump invoked the privilege. President Biden waived the privilege. So we have a stalemate. The court said, well, we'll temporarily block until we have a ruling from the DC Circuit. They have an expedited process where they're going to hear the argument on November 30th. This is blistering fast.
Yeah.
Brief the case now and come in on the 30th. But, these are three judges who were appointed by Democratic presidents. It would not be surprising if they essentially waive the privilege and give it to President Biden. And of course, then President Trump can appeal to the Supreme Court.
Thane, pause for just a moment because we're going to bring Amir Bino in as well to talk about this. So, Amir, your thoughts on Mark Meadows not showing up. What does this mean also to other folks? Because I think there was a list of about a dozen people that would be facing this similar action.
Right. So subpoenas only really matter if you can enforce them, right? And so they have a contempt. They held Steve Bannon in contempt for failing to show up, and they referred that to the DOJ. I think that the committee's flurry of subpoenas are to put pressure on Merrick Garland to take some prosecutorial action, present the case to the grand jury on Steve Bannon, because absent that, there's really no incentive for any of these individuals to come before the committee. And as Thane was correctly pointing out, while we've got this legal issue hanging out there as to executive privilege, it would sort of be foolish for anybody to come in and to waive that privilege if it in fact exists. And there are cases, even though Donald Trump's no longer the president, but the Supreme Court has said in a case involving, it was Nixon versus Administration of General Services, that the former president does have standing to assert executive privilege. So you don't have to be in the office to assert that. There's also an Office of Legal Counsel opinion from 2019 arising out of the Don McGahn issue that said that close advisors to the president do not have to show up when Congress subpoenas them. they don't have to. And that's not something that he can be held in contempt for. And this is a basic separation of powers issue.
So you
can't
wouldn't,
command
so you don't expect any of those folks now who have been subpoenaed to show up. You expect them to follow in the steps of what Mark Meadows just did?
I would imagine that many of them will, or if they show up, they may assert executive privilege, or they may not answer any questions. That's the issue. Does he have an obligation to show up? If he does, he doesn't have to answer their questions.
Okay.
It's just a question of whether or not he has to be physically present at the time and place of the hearing.
Yeah, and then Thane, if the DOJ, what action can the DOJ take short of sending somebody to arrest people for not appearing or not speaking, that would then trigger the next legal step that might end up in front of the Supreme Court?
Well, remember, Bob, the DOJ handles this as a criminal matter, but this could be a civil matter, right? You could take the position that, all right, you're claiming in a privilege in your capacity as former chief of staff. Forget that position. We're filing a civil suit against you that has nothing to do with your job, your former job. So look, as Amir correctly points out, right, there is some precedent, but there is also strong precedent to hold the ground, because, we've seen situations where, remember, this is very political. Often one president is replaced by someone from a different party, and they don't like each other, right? In this case, that happened. And so you can see how this would be a presidential spat. You could force the release of documents out of spite to embarrass the other president or to embarrass his. So there's an interesting legal question here, because is it something that is purely the constitutional authority of the president to maintain, or does whoever is in the White House control the privilege?
Yeah, Amir, a final word, and I did wonder, does it make a difference that this is the January 6th committee investigation?
Yeah, so yes, so the final word I'll say this is, as far as civil action, the Don McGahn case, again, the DC Circuit and the district court in DC said that the House doesn't have standing to bring a civil action to get an order that they can then to compel any individual to testify before them. So I don't know that civil action is available. It's really just give the case to Merrick Garland. Will he prosecute? And if he does, then can we appeal it on the basis that there was really no contempt? As far as January 6th, one of the arguments is as well, the only way that Congress can issue a subpoena is if it's in furtherance of some legitimate legislative purpose. And Donald Trump is arguing that none of this is in furtherance of any legitimate legislative purpose. The purpose is to publicly humiliate and shame people who supported the former president. And so therefore, none of this has any legal authority, these subpoenas. So we have to sort of let this legal process play out.
All right, we'll see what happens. Thane Rosenbaum and Amir Benno, thank you very much for laying it out for us.